Is the court heard appeals in the matter of Saxon Woods Investments Limited and Costa and others?
I'm sorry to everybody for the late start. We have actually been talking about the case, and we can repay some time later by sitting a little later if we need to.
I'm grateful. My Lords, before the court rose yesterday, we mentioned the names of Pliny and Pascal and some others. The bad news is I haven't been able to ascertain to whom the aphorism should actually be originally attributed. The good news is that it remains true, and I have been able to shorten my submissions given the extra time. So overall, I hope that's good news overall. My Lords, I'll therefore deal with grounds 5 and 6 relatively shortly. I'll then have a quick word to say on clause 6.3 because I owe my Lord Justice Zacaroli a response, and I have a short further word, if I may, on Smith and Fawcett, the point raised by my Lord Justice Snowden. Then I'll hand over to Malone Jr. on costs, but we intend to be relatively brief on all of these points. Ground 5, my Lords. By ground 5, Saxon Woods says the judge's conclusion that shareholders would have rejected an offer of $75 million or less was unsupported by evidence and/or, he says, was a conclusion that no reasonable judge could have reached. That's part of his argument as to why the buyout order should be unconditional rather than conditional, as we've seen. With respect, that really is desperate. There was ample evidence for a first instance judge to rely on, as the judge did, from which he could draw this conclusion, including evidence from Saxon Woods itself. First, Mr. Loy's own evidence was that shareholders would not have accepted an offer of $72 million. The judge records that at paragraph 258 of the judgment. Again, if I may, my Lords, I'll just give the court the references. That's at Core 13269. The only response to that, so far as we've seen from a learned friend, is in his skeleton at paragraph 62, where he seeks to say, well, essentially, Mr. Loy may have said that, but that was, quotes, given under the pressures of cross-examination. Well, that would rather unfairly impugn both Mr. Loy and certainly the judge's ability to assess his evidence. Second, Mr. Mehta had indicated he was prepared to exit at a valuation of $90 million. The judge referred to that evidence at 165 of the judgment. And over and above that, although this is not referred to in the judgment, there was also documentary evidence before the court that Mr. Aspinall's get-in price had been $82 million, and he wouldn't find an offer of $125 million, quotes, interesting quotes. The reference for that is the core supplementary bundle, tab 25, page 122. And there is also the email at which Mr. Uberoy indicated that shareholders wouldn't accept a valuation of below $75 million. The judge refers to that in terms at paragraph 258 of the judgment, page 269 in the call. Now, on that, and indeed on the first day of this hearing, my learned friend criticised the judge's reliance on that email from Mr. Uberoy on the basis that he was an unreliable witness. Now, that point was also put to the judge before the consequentials hearing, because the judge deals with this point in terms in paragraph 22 of the consequential judgment, which is at page 288 of the call behind tab 14. I'm not going to read it out, but the judge explains why he is relying on that email, and the suggestion, therefore, that the judge had no proper basis for his conclusion, which is essentially the submission made in this regard, is with respect hopeless. That's my first point in relation to ground 5. The second point in relation to ground 5 is that it doesn't follow, assuming against me that the $75 million threshold was unsupported by evidence, it doesn't follow that the judge should have made an unconditional buyout order. And that goes back to the point I made yesterday. In those circumstances, there shouldn't have been an order at all, because they wouldn't have established the but-for causation. And that, of course, brings us back to the contract point in 172, that I've telescoped that point, but I hope the court has it because it ties in to what I was saying yesterday. In other words, without this evidence, it's not that you get an unconditional buyout order, you don't get a buyout order at all. That is shortly my response to ground 5. My response to ground 6 of my learned friend's appeals. Ground 6 appears to be something of a sweeper. In my respectful submission, it doesn't really add anything to the appeal. Like ground 3, it proceeds on what we submit is the erroneous premise that the purpose of the condition attached to the buyout order is to limit Saxon Woods' relief, whereas in reality the purpose of the condition is to establish whether they're entitled or should get any relief. Because essentially it's a causation point. So that's the first point. The second point is that, with respect, we don't understand my learned friend's complaint that Saxon Woods is now, quotes, locked in, quotes, to the company, and to pick up his phrase, seemingly without the protection of clause 6.2. The agreement is still in place. Saxon Woods has not claimed that what my clients did was a repudiatory breach and or has terminated the agreement on that basis. The protection offered by clause 6.2 is the same as it was. It was never absolute for the reasons which I sought to submit when I presented my appeal, especially on my grounds 1 and 2, because it's subject to shareholders and directors exercising commercial judgment, the realities of the market, what offers might be there and what might not be there. But in any event, the judge correctly directed himself that the court has very wide powers under 996. I mean, 996 really does give the court the ability to do, I suppose I should insert an almost anything that it feels appropriate in the circumstances, and deliberately so, because the range of circumstances which might give rise to a 994 petition are infinitely varied, and therefore the judicial toolbox, if I can put it that way, needs to be well stocked, and 996 means that it's extremely well stocked. Finally, we do respectfully submit that ground 6 ultimately is a complaint about the exercise of the learned judge's discretion. And in my respectful submission, the learned judge took account of the relevant factors, considered them, and came to the conclusion he did. Whether a different judge might or might not have reached a different conclusion is not the relevant question. 996 is essentially a discretionary point, and the judge applied the discretion appropriately. Lords, that's all I was going to say on ground 6. Before I hand over to Milena Junior on costs, as I said, there's 2 points I should come back to briefly. The first is to say a word about the interaction of clauses 6.2 and 6.3. And I'm conscious I spent a lot of time yesterday on 6.2, and I'm not going to venture back onto well-trodden ground. But let me just put it this way, and I hope I'm answering my Lord Justice Zacaroli's questions. My first point, which I hope is uncontroversial, is that clause 6.3 cannot and should not be construed in a way which puts a pen through any part of clause 6.2. In other words, they have to be read together. The second point, which is a reiteration of one of the points of common ground I mentioned yesterday, is that in the first phase, i.e. during the investment period, the company and the investors are not required to achieve an exit. They're obliged to work together in good faith towards an exit, and in the second sentence, they're obliged to give good faith consideration to any opportunities for an exit. So a construction, therefore, of clause 6.3, which forces the investors to bring about an exit during the investment period, must be wrong, because it would conflict with clause 6.2. Now, that takes us to clause 6.32. And when I say 6.32, that's essentially a shorthand for the Roman 2 in 6.2. We see that 6.3 has a heading, or sometimes I think people call it a chapeau, from if to shall, and then Roman 1 and Roman 2. And of course, there's an and in between them, so they are additional points. Now, when one is looking at what I'm calling 6.32, the obligation on the investors, if an exit is proposed in accordance with the terms of the agreement, because that's the conditionality for the whole of 6.3, to procure, insofar as they lawfully can, that such exit is achieved in accordance with such proposal. The question which was put to me was whether, on my case, 6.3 has any application in the first phase. That was page 199 of the transcript yesterday. And the short answer, my lords, that we give to that question is yes, it does. But in relation to 6.32, it's a more limited application than on my learned friend's case. That's as a result of the first and second points I made a moment ago. In other words, on my learned friend's case, as I understand it, if in, say, March 2019, the directors put forward to the investors an exit proposal, i.e. an offer, 6.32 would oblige the investors to accept it, even if they think they can get a much better offer were they to hold out. And the reason I say that is that's the Q&A at page 148 of the transcript of day one. Now, that is a harder line than my learned friend takes in his written argument. In his written argument, at paragraphs 42 to 43, my learned friend says it's accepted that during the first phase, an exit in the form of a share sale could only be proposed, such as to engage a shareholder's obligations under clauses 6.3 and 6.4, insofar as the shareholders considered the terms of any offer were acceptable. However, in deciding whether that threshold was met, the shareholders would have to act in good faith. Now, my case is more closely aligned with my learned friend's written argument than his oral response, i.e. the 6.32 obligation during the first phase doesn't kick in until the investors have accepted an offer, and the good faith requirement to which my learned friend refers comes from 6.2. Now that preserves the integrity, we say, of the second sentence of 6.2, which makes it clear that all the investors have to do during the investment period is to give good faith consideration to opportunities for an exit. If, having given good faith consideration, they decide they want to accept it, then in the first phase, 6.32 requires them to do what is needed to get the deal over the line, to consummate that exit. The 6.32 obligation, however, would chiefly apply in the second phase. I've explained how it applies in the first phase, but it would chiefly be relevant to the second phase when, and usually, as my Lord Justice Snowden pointed out yesterday, in this contract, it's for the board to consent to the terms, at least initially, to the terms put forward by the investment bank. Even if the investors don't like those terms, if the board has signed up to them because their consent could not be unreasonably withheld, then 6.32 would then require the investors to row in, so to speak, behind the board, approve the deal and get it over the line. And that ties in my respectful submission, with what I've been calling the more prescriptive nature of the second phase in clause 6.2. If the board, acting reasonably, has no basis for rejecting the terms, then there is going to be an exit on those terms, irrespective, effectively, of the views of the investors, and they have to procure that exit insofar as they lawfully can.
So what does the phrase "if an exit is proposed" mean?
One has to read that back essentially and say, well, what am I dealing with? Am I dealing with what's happening in the first phase, or am I dealing with what's happening in the second phase? And perhaps implicit in my Lord's question is, does that mean that the word proposed may actually mean something slightly different in phase 1 and phase 2? The answer to that is likely to be yes, because what's coming to the investors and the involvement of the investors is different in phase 1 and phase 2. In phase 1, the investors are giving in 6.2 good faith consideration to opportunities. In phase 2, the investors are not involved in the appointment of the investment bank, save that if the work of the investment bank in phase 2 requires some help from the investors, providing information, etc., then under 631, the investors have to assist the investment bank in that, because to give cooperation, etc.
So what does it mean in phase 1?
In phase 1, what it means is if the investors, if you've got to the investors agreeing to give good faith to an opportunity for an exit, and agreeing that this is an exit that they want to do, then 632, they have to get it over the line. I absolutely accept that it's not easy to read them together, but the only alternative would be to say 632 only applies in phase 2. And the problem with that is that really would do a lot of violence to the beginning of 6.3.
It must mean the same in relation to 1 and 2, mustn't it? The governing words don't change depending on whether it's 6.21 or 6.22. Sorry, 6.31 or 6.32.
Yes, exactly. Yes, sorry. Yes, absolutely. Now, but what I would say is this, though. For example, the content of 631 may well be different if you're dealing with a phase 1 case or a phase 2 case. No. And standing back, although I'm not resigning at all from my submission that you have to read the whole of 6.3 as potentially applying to both phase 1 and both phase 2. I'm not resigning from that at all. But stepping back, it is likely, one would have thought, that 631 is more likely to be engaged in phase 1, when you haven't got the investment bank doing all of this, and 632 is more likely to be engaged in a meaningful sense in 632, in phase 2, when until the investors are asked to procure, they won't have been involved in the process, probably, unlike in phase 1. Because in phase 2, it's the bank, it's the directors and the bank. So where we get to is, I absolutely accept, you have to read them consonantly. The content, in reality, may be different in how it actually bites in practice. But in my respectful submission, you have to read, one ought to read, the whole of 6.3 is conceptually and potentially applying to both phases within 6.2. I hope that's an answer to the point my Lord Justice Zacaroli put to me.
Can I? Okay. At the danger of throwing confusion into this debate, can I sort of put a slightly different point to you, just see what your reaction to it is? 6.31. I mean, the problem with this is all, I suspect, around the words proposed and procure. But 6.31 seems to envisage the investors doing a lot of things which actually would be required at a very early stage of a process. Yeah. Which starts when somebody has the germ of an idea and ends when there's a completed transaction, because it's all sorts of things like giving cooperation, the preparation of an information memorandum, teaser, presentations to potential purchasers, investors, financial advisors, yeah, due diligence. Now, I mean, those things could happen either during the investment period, when the parties are working together towards some idea of an exit, but they could also be required during the period after the investment period, when an investment bank is involved.
Second phase, yes.
Second phase, and they could so that bit of the clause could equally well operate actually in exactly the same sort of cooperative way during either end of the process. The procure, I mean, is there something basically wrong? Is the problem with clause 6.3 with sub 2 rather than sub 1? I mean, if there's an error, is it, if somebody's made a mistake in the way the words they've used or the drafting, is it in 6.3 too? Because it talks about such exit to which I think it must mean presumably a proposed exit, which can be at a very early stage of gestation.
Yep.
Under 631. Is really the intent of 6.32 really not to quite as hard-edged as everybody perhaps is thinking about it? Is the wording of 6.3 really really designed to produce a hard-edged procurement obligation, or something which 6.31 is really a very loose early doors idea? It's quite odd, that
It is.
connection, and everybody seems to be focusing on 6.32 as being the one that's right, and 6.31 is being slightly overlooked. But is the error or the infelicity in wording really in 6.32?
I don't disagree that 6.32 has its problems, as my Lord identifies. I would say that actually there were really three problems in 6.3, which I think goes back to my Lord Justice Zacaroli's point. First of all, the proposed point. Secondly, and I'll come to this point, how Roman 1 works in phase 1 and phase 2, the point my Lord started with, and I'll come back to, and then the point my Lord is on now. I certainly agree with my Lord Justice Snowden that 631, what's going on in 631 could conceptually be required both in phase 1 and phase 2. I accept that. Save that, when the directors have appointed an investment bank in phase 2, you would normally expect the investment bank to do most of this.
Oh, well, I'm not entirely sure about that. In the sense that the board just doesn't sit there on its haunches and sort of, I mean...
The board doesn't, but it would be, in my respectful submission, rarer for the investment bank to have to go to the investors and say, we want your help. They would normally be dealing with the board and say, please provide us with this.
Although there is a certain overlap of...
And I accept that. I accept that. And as I said, my submission is not that 1 or 2 only applies in phase 1 or 2. I absolutely accept that 631 could apply in phase 2. The point I was making is it's much more likely to apply in reality, bite more, in phase 1.
Okay.
I would also, with respect, agree with my Lord that such exit must, in my submission, take the reader back to the third line, the proposed exit. The such exit in the last line is the proposed exit in the third line. That must be right in my respectful submission.
Yeah, because
which I think is what my Lord was effectively saying.
Yeah, and it says, is achieved in accordance with such proposal. It's just a proposal.
And the such proposal is the proposed in the first line.
Yeah.
The fifth word.
So the question really for you, and I know it's always dangerous to sort of seize on a gift horse that's delivered, and it's not intended that way. But everybody's been assuming, or seems to have been, or certainly Mr Davis's argument is, I think, that it's a hard-edged 6.3 procurement obligation.
Yeah, which is
odd. To bring it about, actually,
exactly.
But there's a slight oddity about it having a hard-edged procure that is actually achieved in a court when it's just actually talking about a proposal which could, on the face of it, equally well apply in the first phase. I think that may be, in a sense, your argument.
Exactly. I mean, it goes back to my first point, which is you've got to read the two together.
Yeah.
And whatever the first phase of 6.2 is, it's not hard-edged. And therefore, to make it hard-edged, the point I was starting with today, that to make it hard-edged through 6.3 has to be wrong, because they have to be read together.
I think your point is that 6.32 is it's a follow-on.
Yes.
Once the deal has been approved,
exactly.
Either it's been consented to by the board of directors in phase 2, or it's one that everyone's agreed on in phase 1.
Exactly. And of course, if it's a deal in phase 1 that once everybody has agreed on, because everybody in phase 1 are the investors, the procuring obligation, you wouldn't have thought there's very much to do if they've just all agreed to it.
But that does mean that read that way, once you get into the post-investment period phase, you've got a got a hard-edged obligation at the end of 6.2. I engage an investment bank to cause an exit, provided the board of directors consents, and such consent not to be unreasonably withheld. And so, in a sense, it's that drives the hard edge to 6.32.
Yes.
Not the other way around.
Exactly. It's not 6.32 which is giving the steal in this. Such steal as there is has got to come from 6.2.
Yeah.
And although I agree that, just to pick up that point, although I agree the board of directors is engaging the investment bank to cause an exit, that my lord has my submissions to, in reality, the investment bank can't cause the exit. What that really means is do its best to obtain an exit.
Yeah, but then the board of directors is obliged not unreasonably to withhold its
Once the investment bank has come back with an offer.
So if the investment bank comes and says, look, we've got a buyer for all of the assets here, let's do an asset sale, good price.
Yeah.
The board of directors would have to have a good reason to say, actually, no.
That's right. And they'd have to say something like, okay, your price is 95, that is a good price, but we've got an offer in our back pocket of, 100.
Yeah, what they couldn't say, I suspect, is you, the investment bank, have told us that 95 is a good price now, but, perhaps if you wait a bit longer, something might turn up.
No, something like, look, there's going to be a range, isn't there? And the cases show that not unreasonably withheld is very fact sensitive. You've got Mr McCorber at one end, and you've got my example from yesterday where you've got an absolute, sorry, I use this in a different context. You would have, let's say, the board say, we've got an offer which can consummate in a month, it's at a higher price, and the time value of money means it's a better bet.
Yeah.
There's going to be a range.
But it follows from your acceptance that the words in the end of 6.2 during the investment period are an error, and it means within a...
Oh, everybody accepts that.
Period. Yeah, everybody accepts that.
That's common
That in a sense you can't just adopt a McCorberish approach. If the investment bank says, look, the offer on the table is a good deal, the directors have to take it, basically.
Yes, and although, without wishing to split hairs, the reason why I would say Mr McCorber is out is not so much really because of that point, it's because it will be unreasonable to say otherwise.
Okay, well, I don't disagree.
The roads that come to,
Thank you.
But Lords, that was all I was going to say on 6.3. Can I take a moment on Smith and Fawcett? And can we hand up copies of Smith and Fawcett, which my Lord Justice Snowden referred to yesterday? Can I apologise for the fact that they're highlighted? I'm afraid I was unable to do the line on the side of the page, so I'm afraid all I could do was electronic highlights. We've prized it to my learned friend, so I apologise for that. But to make it absolutely clear, both the highlights and the underlining are mine and not Lord Green, Master of the Rolls. My Lord, and I can take this fairly quickly rather. My Lord, Lord Justice Snowden put to me if we go to the judgment at 306, the first part of that judgment, which I've highlighted, and we had the debate as to whether the placement of the bona fide, this goes to the point whether, so to speak, the action has to be bona fide or the belief has to be bona fide. That was the debate we were having. And my Lord Justice Snowden referred to the first bit, and it's really that first sentence. They must exercise their discretion bona fide in what they consider, not what a court may consider, is in the interest of the company, not for any collateral purpose. And the suggestion was that in this context, bona fide refers to the exercise of the discretion, i.e. what they do, and that tied in with the point in the statute at 170 subsection 4 that you need to construe the new section, section 172, having regard to the previous law, as I understood the point that was being put to me.
Yes, you see, because you say, provided that the... Let's get the wording of the statute in front of me.
Yes.
Let's quote it. You say that in the statute 172(1), the requirement of good faith
Yes,
only applies to the consideration,
exactly, and not the action.
and it doesn't comply. It doesn't. Whereas Lord Green, on the face of it, does three things in this sentence, which, as I say, is just, as I understand it, one of the most time-honoured sentences
Yes.
in company law. They must exercise their discretion bona fide. Court, in what they consider, not what the court may consider. In other words, it's their subjective consideration, not what a court's consideration is. It's subjective, not an objective test. Is in the interest of the company. So that's a sort of business.
Yeah.
Whose business judgment is this? Is it anyway? And not for any collateral purpose. And that's the Howard
Yeah.
Smith and Ampol type.
Exactly.
Powers are given for a particular purpose, and you can't exercise them for a different one.
Exactly.
So in that sentence, he's encapsulated what is now unpacked and
Yeah.
set out at great length in section 171, section 172, 171 and 172, effectively. So if what you say is right, the law has now changed,
Exactly.
subtly but importantly,
Yeah.
from what it was at common law before the 2006 codification. And I use the word codification loosely, but everybody thinks it's codification.
Yeah, exactly. It's codification brackets C170 subsection 4, essentially. My Lord, I respectfully agree that is the, so to speak, issue that these exchanges have highlighted. The first of the 3 points, which my Lord distills from Lord Green's statement here, is the relevant one for these purposes, i.e., is it the consideration that has to be bona fide or the actions? And I have two answers. First, as I submitted yesterday, I do stand on the words that Parliament has used, and I say those words are clear. And if it turns out that there has been a change of the law, notwithstanding 170 subsection 4, then this court has to apply the words of the statute. That's the first argument I give, but actually the reason why I wanted to show my Lord the judgment is because I want to make my second argument, which is the point I put to my Lord as soon as my Lord quoted the words, and I said, with respect, is that what Lord Green is saying? We had a debate about, so to speak, where bona fide went. And I wanted to show my Lord that later in the judgment, if we turn to page 308, when the learned judge comes back to this point, the passage which I've highlighted, the question therefore simply is whether on the true construction of the particular article, the directors are limited by anything except their bona fide view as to the interests of the company. And I do rely on that because in my respectful submission, that supports my submission that it's the view that happened that has to be bona fide, not the action. And of course, when in my submission, when one reads that with the passage which my Lord put to me at the beginning of the judgment, this judgment does support my reading of, so to speak, the pre-existing law. I also rely on right at the end of the judgment, and just to be clear, Lord Justice Luxmore and Asquith, Lord Justice Luxmore and Mr Justice Asquith agreed. The last page of the judgment, again I've highlighted it, there is no ground here for saying the director's refusal has been due to anything but a bona fide consideration of the interests of the company as the director sees them. Now, I absolutely accept that the particular issue that my Lord is putting to me, i.e. if you act in a nefarious way but you have a bona fide view, you honestly believe, in fact believe, that this is in the interest of the company. That point itself doesn't arise in Smith and Fawcett, and we haven't yet seen a case where this particular point has arisen. But I wanted to show my Lord the whole of Smith and Fawcett.
So, I mean, just so we understand I mean, I can thank you for that. I mean, I can see those other paragraphs, obviously those other sections. Do you accept that, in general terms, under the equity, the law, a fiduciary has to act honestly?
A fiduciary has to act honestly vis-a-vis the person to whom he owes fiduciary duties. Although the core, and I am choosing my words carefully because one has to be careful here, the core obligation of a fiduciary is loyalty. That's stated frequently, especially in Mothew.
Yeah.
We also have to bear in mind that, again, I think it's Lord Millet, isn't it? Not Lord Justice Millet in Mothew.
It's Lord Justice Millet.
Is it Lord Justice Millet? Sorry. As Lord Justice Millet, as he then was, says in Mothew, fiduciaries owe fiduciary duties, but not every breach of duty by a fiduciary is a breach of fiduciary duty. And that's important because you can do things. I think this was a point put to me by my Lord Justice Edis. A director may do things which sound in liability in all sorts of ways, but which don't amount to a breach of 172.
Yeah, but okay, but just...
So although normally, so to come back to the, sorry, forgive me, although normally, therefore, of course, a fiduciary would have to act honestly, it doesn't necessarily, in my respectful submission, follow that a fiduciary has acted dishonestly, that he has necessarily acted in breach of fiduciary duty. May often be the case, may not always be the case. And that follows from the loyalty point and from the Mothew point, if I can call it that. Of course, just to be clear, we're having an interesting debate here, and as we respectfully should, as to the ambit of 172. The court won't, I hope, lose sight of my point that in this case, having heard the witnesses, the judge found that Mr Costa had acted in good faith, and therefore we're talking about dishonesty here because we're focused on what does 172 mean. I hope the court won't lose sight of the fact that ultimately we have to apply it to the facts of this case, but the court will have that point.
Yeah, that's paragraph 208 of the judgment you were going to.
And there's other bits as well.
But there is a question.
Yeah.
Okay, so, but just to follow through my point, and I'm just, sorry, just give me 1 second, but I'm just trying to get it up. But in Bristol, and because what I'm interested in is that a director of a company is the most numerous and frequent example of a fiduciary that we have. I mean, there are lots of other fiduciaries, but directors are probably the most numerous.
In fact, yes.
Yeah. And what I'm trying to understand is whether the result of your submission, if it's correct, is that the directors as a species of fiduciary have different duties to those of fiduciaries more generally, where Section 172 doesn't apply.
Yeah, I absolutely see where my Lord is going.
And because if that is the import of your submission, then that's about as fundamental as it gets in terms of equity in companies.
Yeah.
Because for ever since I studied the law, everybody just assumed that directors' fiduciary duties are the same as every other type of fiduciary duties in the core sense. I mean, obviously there are different for all duties. It's why doing company law and equity and university together was a good time saver. You could sort of just read across. Now, is the consequence of what you're saying to us that there is a distinction between fiduciaries and company directors? And if so, why? And if not, why not?
Yeah. My Lord, I don't think that there is, I'm saying there is a distinction, save that I don't want to reserve from my proposition that ultimately, when it comes to directors, one has to apply 172. Now, so the real question is, can a fiduciary ever act dishonestly and still act, and still not be in breach of fiduciary duty?
Correct.
Yeah. My short answer to that is yes, that can be the case. It may be rare cases, but that can be the case because the core duty of a fiduciary is loyalty. Now, can I just distinguish, if I may, two points? A director is not going to be able to say, my duty as a director meant I had to act unlawfully. You can't say that. It doesn't follow, though, from the fact that you acted unlawfully, that you acted in breach of your director's duties. One is not a corollary of the other.
No, but you see, I have some. I mean, what Lord Justice Millett said in Bristol and West, since you referred us to it and you're right to, is this. A fiduciary, I'm reading from page 18, the fiduciary is someone who's undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty.
Yes.
The principal is entitled to the single-minded loyalty of the fiduciary.
Yes.
This core liability has several facets. A fiduciary must act in good faith. He must not make a profit, and there's a semicolon. He must not make a profit out of his trust, semicolon. He must not place himself in a position where his duty and his interest may conflict, semicolon. He may not act for his own benefit or the benefit of a third person without the informed consent of his principal, full stop. This is not intended to be an exhaustive list, but it is sufficient to indicate the nature of fiduciary obligations,
Yeah.
full stop. Now, I sort of think Lord Justice Millett might have been quite surprised since he talked about, the first thing he said is the fiduciary must act in good faith.
Yes.
What does acting in good faith mean there?
It means acting in good faith to, as part of his overall obligation to act loyally in the interests of his principal.
So you say it doesn't mean act honestly.
It will normally mean act honestly, but it doesn't follow from the fact that you have acted dishonestly that you are necessarily in breach of a duty of good faith. For example, if an agent has a principal, an agent may sometimes be loyally acting in the interest of the principal by not fully informing the principal of everything. It's going to be a rare case, I accept. But I don't want to get too far into that, because ultimately I do want to make and rely on the submission that ultimately what's happened here is that Parliament has set out in 172 the way it works for company directors. So, of course, my primary submission is going to be, obviously, that the incidence of the fiduciary duties for company directors is the same as for everybody else. That's obviously going to be my first submission. If I need to, then obviously I will rely on my alternative submission that ultimately, if what Parliament has done in the 2006 Act is something different to where the law leaves other fiduciaries, well, so be it. And I appreciate that's going to be a more difficult submission.
Right,
but insofar as I need to align it, I make it.
But in essence, I think, and to be somewhat blunt about it, but it's using an expression that was used yesterday, you say that in relation to company directors, this Section 172 duty allows them to say the end justifies the means, or my belief as to the end justifies the means.
Provided the belief is actually held.
Yeah, I actually believe.
Yes. That the end justifies the means. Yes, that is my submission. Yes, I have to say that, and I do say that. That is my submission on 172. Absolutely. And of course, let's not forget, as a matter of reality, because at some point, even equity has to coincide with reality at some point. The reality point, what I've been calling, it's a shame that raised eyebrow won't make it onto the transcript.
I think did you make that submission to the Supreme Court a few weeks ago?
What
about the duties of equity?
Yeah, oh yes. This is on the Rockover case.
Yeah, I suspect you got a few raised eyebrows if you did.
Well, we had a 7-bench court, so we had more eyebrows in issue. 7 the judge bench rather. So I've lost my train of thought. Yeah, sorry. The other point is to come back to reality, that the second, what I've been calling the second sentence, or the second part of Mr. Justice Jonathan Parker's judgment kicks in, i.e. the more startling the proposition that you were doing this, but you really thought this was in the company's interest, the less likely it is that the judge is going to believe you. But putting that point to one side, yes, my submission is that the ends, if the director believes that the ends justify the means, then yes, that is 172. And in my respectful submission, that's supported both by the words of 172 and Smith and Fawcett, properly read, the whole of Smith and Fawcett. It's focusing, the bona fide focuses on the consideration, not on the action.
Can I just raise this point, which is a completely different point?
Right.
That the Saxon Woods argument is not just about misleading the board or acting dishonestly. It's also that the judge misunderstood the test of acting in the interests of the company. Because acting in the interests of the company is acting for the benefit of the members as a whole. The members as a whole have agreed on a strategy to work towards an exit by the end of 2019, assuming that's what the clause says. And Mr Costa preferred his own interests as an indirect investor to get as much money as possible later on, as opposed to the interests of the company. And what we've been debating so far doesn't answer that point, does it?
Well, but my lord, it does, because the question still is, did Mr Costa actually believe that getting the later offer, if I can put it that way, was in the interests of everybody? This goes to the heart of, they wouldn't like it. They may not like it if I told them, but they'll thank me in the end. It goes to the heart of that, because what he's saying is, actually, if I can get, if they're going to get 100 on the 30th of December 2019, but I can get 250 on the 1st of February, everybody would be delighted. Now, of course, that may change depending on what the figures are. If the figures are 100 and 101, then not. But it doesn't go to his bona fide belief. And the judge, Mr Costa was cross-examined for 4 days. I do rely on the point I made in response to my Lord Justice Edis yesterday, where if the challenge here is, well, he can't be within section 172 because he didn't have regard to, and then the various subsections, that, so far as I've been able to see, wasn't put to him in terms in cross-examination. And if the evidence isn't there, and therefore the judge didn't deal with it, that's not a criticism of the judge.
So your answer, I think, is that he wasn't preferring his own interests. He would genuinely believe that this was the interests of everybody.
Absolutely, and that ties in with what the judge says right at the start of the judgment, which is, at trial, both parties alleged, each party alleged that the other had some nefarious scheme. The judge rejected all of that. Neither party was acting dishonestly or for a nefarious scheme. That's all smoothed out of the way. So, yes, Mr Costa might have, so to speak, got what the contract means wrong. All right. But the central finding that he honestly believed that the others would thank him in the end is enough in my respectful submission for 172.
So let me follow my Lord's question up, if I may, with a similar example, but a company law example. And the articles are a contract between the members. The articles impose a restriction on managing director's authority. But the managing director sees an opportunity which he genuinely believes is going to be in the interest of the company, but he knows or believes that other members of the board won't back him, and they are required to authorise him to enter into the contract. His fiduciary duties, you'd say, provided he really believes that it's in the interest of the company to go for it, would both allow and indeed require him to act without authority in breach of the articles and commit the company to the contract, using his ostensible authority to do so.
Yeah.
And that wouldn't be a breach of his fiduciary duty, a breach of 172, because he's acting in what he thinks is the best interest of the company. And the fact he's breaching the articles, the agreement that all shareholders have as to how the company should be run, is neither here nor there.
Yes, that is the consequence of my argument. Save that. I take issue respectfully with the word require, because as I said earlier, a director is not going to be able to say that the fiduciary duty requires him to do something unlawful.
Right. Okay,
So
but it permits him. So, take out the word
but
require.
I'm only saying that because it's on the transcript. But I think for the point my Lord is putting to me, the word require was actually unnecessary, if I may say respectfully, because the central point is he could do that without necessarily breaching 172.
Okay.
Yes, that is a consequence of my argument. Yes, I mean it's the same. If I may say, it's the same point really is
Yes, well, it was picking up my lord's
proceeding the
point
board,
that
but it's just a different example.
my lord was giving you saying, well, it doesn't make a difference that this is a contract between all the members and the
Yes.
articles are a similar contract. But you say, either way,
Yeah.
it's provided subjectively the director believes.
Yeah, and it's going to be very hard in that case for the director to persuade a High Court judge that that's what he actually thought. But that's the test. I mean, the cases say time and time and time again, it's subjective. There's no hint of any objective element in the test anywhere, save that, what I've been calling the Mr. Justice Jonathan Parker second sentence point, or whatever it is, save that, if objectively what you're doing is very nefarious, it's going to be much more difficult to persuade the judge. Otherwise, the cases say time and time again, it's subjective. And there's no hint in my submission in any of the cases that there is this, but what you do has to be proper or not nefarious, or whatever language we want to use.
Yeah, but you can take an example of the director. The matter is discussed by the board at a meeting. The managing director firmly advocates his views. Everybody else says, absolutely not. You're bonkers. But he genuinely believes he's right.
Yeah.
So he just walks straight out of the meeting. And he will be believed by the judge when he says so in court. But he walks straight out of the meeting and does what the board has just said should not be done. And he says it's not a breach of fiduciary duty because I actually believed that was in the interest of the company, and the rest of them won't thank me if they knew what I was about to do, but they'll be grateful in the end.
But that's going to be difficult because in those circumstances they did know what he was about to do.
No. He didn't give them any clue that he would actually go out. He just participated in the board meeting and they said no. And he just went straight out and did it because he took the view. They won't thank me if they knew what I was about to do. They wouldn't thank me. But trust me, it'll be all right in the end.
There may be a number of other problems with the director's conduct there, and there may be, as my Lord Justice Edis put to me, there may be other sanctions available and consequences, perhaps even consequences in other parts of the law. But the central question is it a breach of 172? And the necessary consequence of my argument, I accept, is that it isn't. I mean, these are further iterations.
I'm just putting to you some obvious illustrations that may occur. And
No, absolutely.
making sure that we get your answer on them.
I hope I've been very clear that is my case.
Yes.
And also why it is my case, based on the words in the statute and looking at, for example, Smith and Fawcett. Yeah. And also the absence of a case, the absence of any case where the director has acted sort of in what he actually believed to be the interest of the company, but has acted in a nefarious manner, and the court has said, therefore, you're in breach of 172. We still haven't seen that case. That's a bit of a Radio 2 segue to my final point. It's taken a little longer than I...
Sorry,
sorry.
Just for clarity on this point, because it might be important. In answering my question, I think there were two possibilities. Mr. Costa knew that what he was doing breached Article 6.2, or he didn't know that it did.
Yeah.
Did the judge make a finding on that? At 200, what the judge says, Mr. Costa pursued a strategy which he knew or should have.
Yes, exactly. That's all we have.
Is there a finding that he knew this was not what was contrary to what had been agreed?
No, we respectfully...
200 I was referring to.
Yes, I mean, if the judge says, or as the judge says, which he knew or should have known, that, in my respectful submission, is not a finding that he knew, because, well, I mean, it's an obvious point, my lord. So there's no finding that he knew it was in breach. There's certainly a finding. The should have known is a finding. I would certainly accept. The should have known is a finding that a reasonable person in his position would have known, which may be relevant to Jonathan Parker's second sentence. My lords, unless there are any further questions on that point, I was just going to say this. I received this morning, kindly from a learned friend, 2 cases which I understand go to the 172 point. Of course, when I reply later, I can only reply on my appeal, but I hope the court will allow me to say a word about those cases because they're being introduced by my learned friend in reply, if there's anything I need to say about them. I just wanted to put a marker down because otherwise, technically, I wouldn't be able to say anything about them. But we can come to that.
I don't think we know what they are, just out of interest.
Oh, you don't know what they are?
No.
Oh, well, I don't want to steal my learned friend's thunder, but they're cases which, on this side of the court, don't take the matter any further, and on that side of the court, will obviously provide the answer to all my Lord's questions. That's what they are.
We wait with bated breath.
Bated breath, my Lord. Unless I can assist further, may I please hand over to Malone Jr. to address the court on ground 7?
Yes, thank you very much. Yes, Miss Burns.
My Lords, on any basis, there's no reason to disturb the judge's exercise of his discretion as to the appropriate costs order. The overarching point is that all the judge has done by reserving costs to the quantum trial is hold the ring. That is entirely unobjectionable. Indeed, it's generous to Saxon Woods in circumstances where it hasn't established prejudice and the value of the shares is unknown. On Saxon Woods' primary case, Ground 7 depends upon succeeding in its argument that the court should make an unconditional buyout order. So if its appeal otherwise fails, that primary case on costs fails too. But even if its appeal succeeds, it doesn't follow that Saxon Woods should get its costs. The appropriate costs order depends on the valuation of the shares. And in a world in which Saxon Woods has succeeded in getting an unconditional buyout order with no threshold value, the valuation is entirely at large. Saxon Woods would need to establish that they were worth a substantial sum in order to be considered truly the winner. I don't think we need to go to it, but I'll give your lordships a reference for your note. It's the case of Ashdown and Griffin, which is in the authorities bundle at tab 34, page 1239. That was a case in which the Court of Appeal reversed a costs order against a respondent when unfair prejudice had actually been found, but the shares were valued at nil. The reasoning is at paragraph 35, page 1250, and it's not limited to cases where the shares are valued at nil. Lord Justice Nee said there, the petitioners brought the proceedings with a view to obtaining a substantial sum for their shares, and they wholly failed in that objective. Well, Saxon Woods too seeks a substantial sum for its shares, as confirmed by my learned friend at the consequentials hearing, when he refused to rule out the possibility that Saxon Woods wouldn't bother enforcing a buyout order if the shares were valued at a derisory sum, to use his phrase. So if Saxon Woods doesn't get a substantial sum, it will be substantively the loser. It's therefore entirely appropriate to leave the question of costs to the judge hearing the quantum trial. Now, remarkably, Saxon Woods also argues that it should get its costs even if the rest of its appeal fails and its entitlement to a buyout order remains conditional. But once again, this argument is based on the erroneous premise that Saxon Woods has established unfair prejudice. That's clear from paragraph 73 of my learned friend's skeleton, where he tries to make good the submission that Saxon Woods was the winner of the liability trial. He says twice in the sub-paragraphs of 73 that the judge found that Saxon Woods had suffered prejudice, unfair prejudice. As we have already explained, ad nauseum perhaps, that is wrong. Prejudice has yet to be established and may never be established. And by this ground of appeal, Saxon Woods is trying to shut Mr Costa out from arguing costs in the event that it fails to establish prejudice at the second trial. This is another point where the terms of the Burton order, if I can refer to it in that way, are important. If Saxon Woods were to get its costs of the first trial now, Mr Costa would suffer a double injury as a result of the judge's misunderstanding of the Burton order. First, it gives Saxon Woods 2 shots at establishing prejudice. And second, if Saxon Woods loses at the quantum trial, and that it fails to prove that an offer over $75 million would have been received, well, that is something that ought to have been decided against it in trial 1. And if it had been, Mr Costa would likely have got his costs of trial 1, because he would have been substantially the winner. It would be most unfair to make Mr Costa pay the price, quite literally, of the judge's error by ordering the costs of the first trial against him now. Returning to Ashdown and Griffin, where there was prejudice, but the shares were valued at nil, the position here is a fortiori, where prejudice has not even been established. My learned friend cites the case of Langer and McKeown in his skeleton, as authority for the proposition that the proceeding should be considered in stages rather than as a whole. In my respectful submission, his reliance on that case is misplaced for 4 reasons. The first is that was a case where, unlike this one, there was no doubt as to who had won the liability stage. Second, the quotation from Langer, which is set out at paragraph 72 of my learned friend's skeleton, makes clear that the point being made there is really about discrete points or issues dealt with as separate applications or at separate hearings within the overall litigation. It was part of a more general discussion about the policy considerations behind costs rules. Well, that's not the situation here. And as to the reference within that quotation to there being a salutary rule that costs follow the issue rather than the event, well, A, not even Saxon Woods is arguing for that. It's not proposing to pay the cost of its failed case regarding Mr Costa's alternative scheme, for example. And B, as the word salutary indicates, the purpose of that rule is to encourage parties to be selective in the points they take at trial. It needn't be rigidly applied after the event, when that ship has sailed, and where, in contrast to the position in Langer, in this case the trial judge did not express a view that the parties had taken unmeritorious points. Third, the Court of Appeal's decision on Ashdown and Griffin at paragraph 38 supports an approach to costs which looks at the proceedings as a whole. And fourth, and I come back to my overarching point, in any event, by reserving the costs of the first trial, the judge's order doesn't preclude the quantum judge from looking at the proceedings in stages. It simply holds the ring. As for the conduct points, we've answered them fully in our skeleton argument at paragraphs 64.3 and 65, and I don't propose to revisit them all orally. Suffice to say, we do not accept the criticisms of Mr Costa's conduct, and neither did the judge. He was in the best position to assess the parties' conduct, and he didn't think it merited an immediate costs order against Mr Costa, still less an order on the indemnity basis. And in any event, the criticisms don't justify appellate intervention on costs. It's unsurprising and unobjectionable that both sides fought hard in complex high-stakes litigation. My lords, unless I can assist you further, those are my submissions.
I mean, if you're wrong, and there has been unfairly prejudicial conduct, but it's just not known what value is to be attached to the petitioner's shares. They went into a hearing seeking a buyout order, and your side objected to that, and the trial was fought out over the issues which would or wouldn't justify the court making a buyout order. That's where the costs have thus far been incurred. Why should the incidence of those costs on issues of liability depend upon the actual value of the shares at the end of the valuation stage of the proceedings?
Well, my lord, I would come back to what is said in paragraph 35 of Ashdown and Griffin, which is that the point of alleging unfair prejudice is not to establish the point for its own sake. The petitioner seeks a substantial sum for their shares, and that is what Saxon Woods did. In the discussion in the consequential hearing about whether Saxon Woods would bother enforcing a buyout order at any price, the figure mooted by the judge was 6 million for Mr. Saxon Woods' shares. And in response to that question, my learned friend didn't rule out that they might not enforce an order. So that would demonstrate that they haven't really got what they wanted. And therefore, they're not really the winners overall on liability.
I mean, have there been any open offers made by your side to buy their shares?
I would need to take instructions on that point, my lord, if I may. No, there haven't.
So, if your client was prepared to, if your client believed the shares were worthless or worth an insignificant amount, it would have been open to your client to make an open offer to buy the shares, and so we could have just avoided the liability trial. But your client chose to fight the liability trial, so if liability is lost, I appreciate it's different if it's won, but if liability is lost, why shouldn't your client pay the costs? I mean, the order that you seek deprives, for example, the court of making any issue-based costs order.
I'd simply come back to the overarching point that all that's happening is that the ring is being held right now. Nobody's being shut out from arguing anything at this point. We just have to wait a little bit longer. And that is not hugely prejudicial to Saxon Woods, and it is the fairest outcome. And as your Lordship's question fairly illustrates, there are many possible permutations of the outcome of this appeal and the second stage trial, if there is one. And on that basis, I say it's a good reason to let the judge's order on costs stand and deal with this all further down the line.
Thank you very much. Thank you. Mr Davis.
My Lords, I see the time. I wonder if this would be a convenient point for the mid-morning break, and then I'll have a free run till the short adjournment.
Yes, that's very sensible. We'll do that. Thank you. 10 minutes.
All right.
Push.
Yeah.
Great. Thank you. Thanks.
One for each.
Thanks very much. You entry? No, I refused last year.
Diary conflict. Yeah, that'll be good.
Yes, I haven't got the body.
They train you up.
No, I don't.
That's the last thing that I've seen you
Obviously,
Really
it's not intense to talk about.
right.
It's hard to follow up what else we talk about. So I'll go to. That'll foster the program. Yeah, no, there's something in it.
So I'll take that as a vote of confidence.
Yes, Mr. Davis.
My Lords, I'm going to start by responding on Mr Costa's appeal, and in due course I'll then turn to my reply submissions on our appeal, Saxon Woods' appeal. So starting with Mr Costa's appeal, ground 1, specifically ground 1A, which is the construction of clause 6.2. The first point I'd like to make is that in my learned friend's submissions yesterday, he developed a completely new case on construction of 6.2. So not only is this not a case that was advanced at trial, but it's not the case they advanced in their skeleton argument for this appeal. The first we heard of it was yesterday. So the skeleton argument contains none of the syntactical analysis that my learned friend spent time on yesterday, nor was there any reference to the phrases or labels protective phase, prescriptive phase, or anything of that nature. More substantively, my learned friend placed no reliance at all in his oral submissions on the interplay between directors' fiduciary duties and the construction exercise. So, in essence, the argument that features quite heavily in the skeleton, paragraphs 11, 19 sub 5 and 19 sub 6, is that the obligations of the company under clause 6.2 are subject to the director's duty to act in what they consider to be the best interests of the company. That indeed was also an argument that featured on the application for permission to appeal below, where it was sometimes referred to at least as the director's duties override. Now, given that that argument was not advanced at all by my learned friend orally, we rather assume it's no longer relied upon. But as it goes, I mean, whether it's dressed up as part of the interpretive exercise or as some kind of overriding principle of construction, we say it's a radical proposition that can't possibly be right. It can't be right that where a contract imposes obligations on a company, they should somehow only be read as applying subject to the director's duties. That's essentially what is being said. And clearly there's nothing in the express terms of the contract to that effect, and express words would be needed, because the idea that the shareholders would make the exit process subject to the general ability of the directors from time to time to decide that it wasn't in the best interest of the company to proceed would be very surprising. Indeed, it would be extraordinary from the perspective of the minority shareholders, for whom the exit process was a protection, a guarantee, if you like, that they would be able to realise their investment in circumstances where they're a minority and they don't have control of the board. The idea that they would have subordinated this process to the director's ability to take a view in accordance with their duties, purportedly, would be extraordinary. So that construction can't be maintained. We don't think it is relied upon anymore. It's really an attempt to construe into the document the entire architecture of of fiduciary duties, which would be bizarre, we would suggest.
Which is the core paragraph in their skeleton, which you say is the argument run on construction?
So paragraph 11 of their skeleton puts it very high. They say it's a well-established principle that, I should just read it. So it's tab 8. This is page 97 of the core bundle, paragraph 11. It is well established that a company's contractual obligations will generally be read subject to or consistent with the director's duty to act in the interests of the company as a whole. I suggest that's simply not correct, and the authorities don't support that proposition either. But it hasn't been developed orally, so we can only surmise that it's been abandoned. My Lord, the point is then further developed in paragraphs 19 sub 4 and 19 sub 5. So they've abandoned that central plank of their original argument of construction and come up with something entirely new since their skeleton, which is based purely on an analysis of the language of the provision. Although, of course, that analysis consistently and determinedly ignores the crucial words in the first sentence, no later than. It's almost amusing the lengths to which they go to avoid using those words, but we say they're very important. And indeed, I don't believe my learned friend ever explained how those words are to be interpreted and given effect in this clause. But just doing the best I can to understand their current position, as I understand it, what they now say is the first sentence is concerned with defining the term, the investment period, being the period up to the end of 2019, and that they say that the effective, or at least the most effective obligation in the first phase is actually contained in the second sentence, concerning giving good faith consideration to any opportunities for exit during the investment period. But if no such opportunities arise, the obligations under clause 6.2 in respect to the first phase, on their case, could actually be complied with by doing nothing. And hence my learned friend's answer to Lord Justice Edis's question about whether it would be legitimate to start from scratch on New Year's Eve 2020, to which the answer was, well, yes, that might be a situation that could be arrived at consistently with the obligation. As for the words in the first sentence requiring the company to work in good faith towards an exit, it was said that this merely required that nothing was done to undermine the process. We say that's, with respect to a completely unsustainable approach to construing these provisions. It requires substantially reimagining the clause by moving parts of it around and ignoring words, notably the no later than words, but also the words in addition at the beginning of the second sentence. Above all, it results in a construction that is wholly uncommercial and cannot reasonably be thought to have been intended. And the judge correctly rejected the argument that merely working towards an exit in some kind of preparatory way, he rejected the idea that that would satisfy the requirement, and that was at paragraph 183. It seems that the current argument is even more extreme than that. They say they could have done nothing. Our position is plainly that any sensible construction of this clause must give real substantive significance to the 31st of December date. That's obvious as a matter of general context, where the investors, and Saxon Woods in particular, as I said before, wanted a reliable mechanism for ensuring that they would exit the business. Even more to the point, the idea that you have to give real effect to this deadline is that it reflects the plain and obvious meaning of the words no later than. Those words are important. It's not just an obligation to work towards something by a date, it's to work towards something by no later than a date, which gives the clear sense that it's a deadline, not an aspiration. In essence, the other side wants to reduce the clause at most to aspiration, and that would substantially denude it of any meaningful effect.
Well, sorry, there are two different points. Is it any part of your case that a deal had to be done by the 31st of December 2019 such that the agreement was breached if it wasn't?
No.
Right. So, I mean, you say it's a deadline, not an aspiration. I mean, it's not a deadline in the sense that a deal had to be done. It's just, I think you say, you had to have started doing something before that date, and you weren't simply allowed to say, we'll do nothing.
That's certainly true, but it's more than that, my lord.
So
the aim was to achieve an exit by that date.
The aim is to achieve it, but that's not a... I'm querying your contrast to a deadline and aspiration.
So it's a deadline, but the clause also provides what happens if the deadline is missed. They really needed to work to achieve an exit by the deadline, but the clause accepted the possibility that they wouldn't hit the deadline, and then a more extreme regime comes into place. And indeed, it would be rather odd, we would say, if for the entirety of the investment period, the obligations were so soft that they could essentially do little or nothing, but then at the stroke of midnight, New Year's Eve 2019, suddenly rather extreme steps have to be taken to cause a sale. And bearing in mind it's accepted that that sale would have to come about within a reasonably short period of time. And just for your note, the judge did find that time was of the essence, and he did find that it was to be implied that it should be done within a reasonably short period of time, and that's at paragraphs 193 to 194. So the idea, in a sense, we say that the rigour of the requirements in the second phase actually reinforces the idea that there was a real deadline, in the sense that they were really expected to have achieved an exit by the end of the year. After all, they had 3.5 years to get there. It was a good faith obligation. And on that basis, the second phase is more backup, or essentially the hard-edged obligations are intended to deal with the eventuality that the deadline is missed for some reason, and in a sense, colloquially, there's to be no more mucking around. We've got to employ an investment bank and get it done. As I say, in my submission, that's not at all inconsistent with there being a deadline that they had to work to. Now, against our construction, my learned friend raises the spectre of a very low ball offer on Boxing Day. Now, I think strictly they could have waited till New Year's Eve, but that's not the real problem with it. The correct way of looking at this is that by then the company and the investors would have had 3.5 years to sort out the exit. During that period, they should have been working in good faith towards achieving that goal, being fully aware of the approaching deadline. So looking at these provisions reasonably, as we must, one would not anticipate it going down to the wire. However, if that situation were to arise and a derisory offer was to be made at that very late stage, then it would be a matter for the directors, mindful of the company's obligations under clause 6.2, to decide whether to propose the offer to the shareholders. Now, of course, it would depend on the very precise facts, but one can imagine an extremely low offer, a derisory sum, being proposed. Well, the directors in that extreme situation might decide it wasn't an offer that should be put to the investors, even though they're 5 minutes to midnight, and instead leave it to the investment bank in the knowledge that they'll have to take over. Alternatively, they could put it to the shareholders, and then it would be a matter for the shareholders, by necessarily unanimously, to decide to vary their obligations. But this is a very extreme hypothesis that the 3.5 years have been wasted, and the company and the directors have put itself into this situation. And that's extreme hypothesis should not be a reason to depart from the plain and obvious meaning of these provisions, as found by the judge. So that's what we say on the application of interpretation of clause 6.2. I'm mindful that the conversation has developed more significant. Well, there's been further discussion between lordships and my learned friend. I mean, perhaps I can just elaborate on other aspects of the clause. I mean, I think I've said enough to, as it were, defend the judge's interpretation of 6.2. But as regards how 6.3 operates, in my submission, it's important to distinguish between an opportunity for an exit, which is what we see in 6.2, the second sentence, and where you have an exit being proposed. And essentially, an opportunity for an exit is obviously a prior state of affairs, a more preliminary situation where the directors and each of the investors have to give good faith consideration to an opportunity. A proposal that looks like it might conceivably result in an exit. It's then a very different matter for the directors to decide, well, are we going to propose this exit? That we say that plainly requires a decision by the directors. And at that point, you would get into 6.3.
Where is any mechanism in the first phase for the directors to have any involvement in this by proposing something?
Well, my lord, I appreciate it. In terms of the first phase, the directors aren't mentioned, but the company is. And so it's the company has to give good faith consideration, so that's effectively the director.
And why is the company giving good faith consideration to the purchase of its shares?
Well, it could be a sale of the business.
Well, it could have been, but,
yes.
But if it's not, what role does the company play? It's the investors then, isn't it?
Well, in this instance, they've... recall, I think on day one, we talked about the close relationship between the directors and the investors. So with these parties, one can imagine that they may have felt that given the directors the degree of involvement and control, even at the first stage, is legitimate because there's going to be a free flow of information between the investor and the directors. But be that as it may, in 6.2 they are considering opportunities for exit, so a potentially very preliminary situation. And then the next step is when they propose an exit, which essentially is the trigger for getting into 6.3. Now, that doesn't mean there's an offer on the table, because one can see from the first Roman numeral in 6.3 that there may be considerable work to be done still. But the directors may nonetheless propose it as effectively a route to an exit, which they would consider to be a perfectly good outcome. At which point, the investors, that is to say all of them, need to cooperate in potentially some preparatory steps, but ultimately with a view to getting that deal done, if all of the I's can be dotted and T's can be crossed, hence the obligation to procure. So we think the key to unlocking the operation of these is to understand that proposing an exit is when the directors decide to take it to the next level, which is where the obligations come in, the harder obligations come in on the investors.
So you would interpret, if an exit is proposed, as being where the directors of the company propose to the investors?
Yes.
Or to themselves as the company, if they
yes.
sell the assets, that a sale be effected?
Yes.
Or be it investigated further?
My lord, yes. And I take some comfort from the fact there is a distinction between two concepts in these clauses. You have an opportunity for an exit, which has to be considered, and then you have an exit being proposed. And plainly that is a trigger for stricter requirements on the investors. And really the only way that could work is through the directors deciding when that moment has arrived. And indeed, one has to see also the warranties under 6.4. So really, once the directors they say, right, this is a decent exit, we should go for it. investors, you've now got to not just act in good faith. You've now got to help us get it done, and that will include giving warranties insofar as it's a share sale.
But I mean, so you say consideration. People just are sitting around thinking about something. It then gets to a stage where the directors say, "Okay, that looks like something we should think some more about. We should investigate more."
I'd go further than that. I would suggest they say this is a deal we think is an exit.
But the trouble is, I mean, some of the things in 6.3.
Well, my lord, it depends on the other party as well, because you can, in a sense, it takes obviously two parties. So the bidder may decide not to cooperate at a late stage, or in a sense, you can propose the exit before it's a binding offer.
Yeah, but I mean, just looking at 6.3, cooperation assistance in the preparation of an information memorandum or teaser. I mean, that's a pretty early stage document.
That may be more appropriate in the second phase. So where you've got your investment bank. So if you haven't managed to get your exit away in the first phase, and you get into the second phase where the investment bank takes over, then the obligations on the shareholders might be slightly different, or the things that shareholders are asked to do to get the exit across the line may be slightly different. The investment bank may require more help. Because we are all agreed, I think, now that 6.3 applies both in the first phase and the second phase. My lords, that's my position on construction. Then we get to ground 1B, which is the application of the clause. Now, this is their appeal based upon the idea that their construction is right, and therefore if they're right, and it's what they describe in their skeleton at least as a looser form of obligation, it was not breached. So this ground is entirely parasitic on them succeeding on their construction. So of course, for the reasons I've given, that is not the case, we say. Now, my learned friend suggested that we don't mount a separate defence on breach. That's not right. We do say that even if we're wrong on construction, and 6.2 is a looser form of obligation, effectively not requiring anything particularly to be done, we certainly say that's still been breached. Just to run through a few of the findings that we would rely upon as supporting that position, even if there is this looser obligation, I'll just give a few points. Mr. Costa was pursuing alternative transactions to a sale. The judge accepted Saxon Woods' case that Mr. Costa had instructed Jeffreys to pursue a fundraising, for example. That's paragraphs 118 to 119. The judge also accepted that Mr. Costa had been involved in negotiations for the acquisition of Bay Capital's shareholding. That's 158 to 159. And he expressly recognised that Mr. Costa was pursuing alternative transactions. And we say even if it's a looser obligation, some meaning at least must be given to the term working together in good faith towards an exit, and working in fact for an alternative, inconsistent transaction cannot be in accordance with that obligation. Similarly, the instructions that Mr. Costa gave to Jeffreys were not in accordance with the company's obligations under clause 6.2. That's paragraph 214 of the judgment.
That's right if you're right on construction, but not if you're wrong on construction.
Oh, well, my lord, he didn't even tell them about clause 6.2 or any time frame.
If the deadline wasn't there, it's less relevant.
It's less relevant, my lord, but not telling them even about the existence of the obligation, we say, is still incompatible with the good faith obligation. And as a result, Jeffreys had no intention of conducting a sale by the end of 2019 and did not envisage doing so. And that's paragraph 74. Mr. Costa actively misled the board by giving the directors the impression that Jeffreys were working to achieve an exit. That's paragraph 202. And Mr Costa was not prepared to negotiate an exit with a buyer who was in any way connected to Mr Loy. That's paragraph 198. Again, on any view, must be inconsistent with any kind of obligation under 6.2. And finally, the proposal by Metric was, in the judge's words, fobbed off. That's paragraph 246. So we say that in the light of the findings I've just referred to, the obligation, even as now framed by my learned friend, would have been breached. I'm now moving on to ground 2, which concerns the second sentence of clause 6.2. So here we are dealing with the obligation. In addition, the company and each of the investors agreed to give good faith consideration to any opportunities for an exit during the course of the investment period, as we've just discussed. Now, it's worth asking, how does this ground relate to the rest of the appeal? We now understand from my learned friend's submissions yesterday that, as I understand it at least, it's specifically this ground, ground 2, that they rely upon when it comes to arguing under ground 3 that there's not been any prejudice sufficient to support the buyout order. In short, they say that the only prejudice relied upon by the judge to support the order flowed from the breach of the second sentence, i.e. the failure to consider the metric opportunity. So that their argument, as I understand it, is that even if Mr Costa did cause a breach of the company's obligation under the first sentence, working in good faith towards an exit, provided that they managed to overturn the judge's findings of breach in respect to the second sentence, they say there was no basis for the buyout order. Now again, this really only came to light yesterday, but one point that would seem to flow from it is that they must presumably accept that it's not going to be enough for them to succeed on ground 1, i.e. in respect to the first sentence, because they say that the prejudice relied upon by the judge in reaching his decision on the relief all flowed from the breach of the second sentence. That's under ground 3. So this does rather seem to leave ground 1 rather hanging. And I suggest that if that's the way they put their case, it has no purpose, because on their case on prejudice, all the prejudice flowed from the breach of, in the judge's eyes, flowed from the breach of the second sentence. So as it stands, I'm not sure where their first ground gets them in the way the case is now being put. Now, of course, from our perspective, it's clearly not correct to suggest that the order made by the judge was founded solely on the breach of the second sentence. We say the breach of the first sentence, the failure to work in good faith, if anything, was more significant in terms of the prejudicial ramifications that it had, and it's all rather artificial and narrow for them to be arguing now that all of the prejudice flowed from a breach of the second sentence. But I'll return to that when we come to ground 3. Just dealing now with the appeal in respect of the second sentence of 6.2. As I mentioned before, the focus of the appeal here is very much on metrics, expressions of interest. In essence, Ms Costa says that the metric proposals would not have been an exit on a proper construction of that term, and so it said that it follows there's no breach of clause 6.2 on account of any failure to give good faith consideration to those proposals because they were not an opportunity for an exit. Now, it bears repetition that the obligation is to give good faith consideration to opportunities for an exit. So the question really is whether the expressions of interest by metric would properly be viewed as representing an opportunity for an exit. Now, one initial observation, my learned friend approached this issue by looking at an email between Mr Loy and Mr Balfour. You may recall that, it's at Core Bundle, tab 15, page 82. I won't take you to it, but it set out some of the discussions between Mr. Lawyer, Mr. Balfour, as to how the deal might be structured as regards rollover, etc. Now that email was 2 months before the first expression of interest served by Metric, which was in September 2019. He also, and of course, crucially, that email would not have been within the knowledge of the company. My learned friend also speculates about what an offer would have looked like in terms of the amount of rollover. So in support of his position that one has to look at simply whether or not there would be an exit, he does two things. He relies upon a document that clearly wouldn't have been in the knowledge of the company and was effectively internal debate going on at Metric. And secondly, he speculates as to what the deal might have looked like when it was ultimately put, which never happened, of course. But that doesn't reflect how the clause would be operated in the real world. And that's for the obvious reason that, as I say, the company wouldn't have had access to the email or indeed any knowledge of it. And really one has to look at it as how the issue would have arisen at the actual time. So put differently, the obligation of the company to give good faith consideration to opportunities for exit can't sensibly operate as if the application depended upon 2020 visibility of the entire details of the proposal. In reality, as actually happened with Metric, a proposal would be made. Behind that offer, Metric might have had in mind all sorts of different options for how it might be structured and financed, but you wouldn't expect those to be spelt out in the initial proposal. Rather, one would reasonably and naturally expect there to be multiple questions to be answered about any proposal. The proposal will be the start of a discussion, a negotiation. And on any reasonable view, we say the expressions of interest made by Metric comprised an opportunity for an exit within the meaning of clause 6.2. I should just perhaps, I'm not sure if your lordships have seen these documents, but I'll show you two of the expressions of interest. They're at the core supplemental bundle. Tabs 16 and 17, so pages 84 and 87. And there's no need, your lordships can just, the first one's a very short document on page 84, and the last paragraph from the first page, based on the information we have received to date in our introductory meeting with Mark Loy, our understanding of Spring's market position and brand, and market companies, market comparable transactions, we value the company at an enterprise value of $110 million for 100% of the share capital on a debt cash-free basis. Yes, so that makes the point it's for 100% of the shares, and that's also actually in the heading. So you see in the underlined piece at the top of the page, to acquire 100% of the share capital. And then
the interest is made on behalf of funds advised by MCP. So in fact, it's actually an offer on behalf of undisclosed funds. Is that right?
Well, I think there are debt funds, so presumably they would be expecting other investors to be involved. They'd be raising funds.
So at the moment, I mean, anybody receiving this letter would say, okay, well, we're not sure who's actually going to be buying. We know what they're offering to buy, 100% of the share capital, but we just don't know at the moment who they represent.
You don't know who's behind them, but you do know that it's an offer from a Metric entity.
Yeah, but you wouldn't automatically discount it or otherwise simply because you would know, for example, that you would. I think I'm trying to
agree. I think yes. I mean, it's an opportunity.
Yes.
Yes.
You don't know at this stage that it's not, even if Lord Walson's right, you don't know at this stage that it's not an exit.
Absolutely.
Yeah.
You've got no information.
Is there
about
anything in the letter about the proposed rollover or anything of that sort at all?
No.
No.
So we go over to the next offer, which is, or expression of interest. It's not put as an offer. And there's a bit more detail. It's on page 87. Again, it's put as acquiring 100% of the shares.
Yes, and in fact, just out of interest, if you were reading it, so just looking at the second page, it says about Metric Capital Partners. And it talks about, we advise 3 fund vehicles currently investing out of our third fund, etc., etc.
Yes, I think, as I say, it's debt funded, I think, on the whole.
Which is domiciled in Luxembourg.
Yes. So a little bit more information actually is provided in the next document. Again, it's acquiring 100%, and you can see here they identify some of their people. Oh, some relevant examples, actually, forgive me, of where they've done previous acquisitions. They set out a rationale for acquiring Spring, why partner with Metric, overview of the proposal, and then this is on page 89. What they do here is they give a bit more detail about how they've come to their figure of 110 million. And indeed, they set it out in some detail over the page on 90, and they, and to Lord Justice Snowden's point, they give some detail about the transaction structure and funding. The transaction will be funded by a mixture of preferred shares or notes and common equity.
Does this imply that the current members, shareholders in the company, will have some continuing interest in its success?
Well, I'd say it implies, it doesn't imply to me in the actual language used, but equally those more educated in the market might fully expect that there would be some kind of rollover, potentially as part of the deal.
Because what they're saying is we will make a really good job of funding this company so that it can succeed.
Yes.
But if it's just an exit for all the members, they won't care whether it succeeds or fails.
Well, I see it perhaps is implicit in that, absolutely, my lord. And I'll come on to what the experts say. I mean, there does seem to be a degree of common ground between the experts. The rollover would be completely normal and to be expected.
But the question is, to what extent?
Indeed, that's a question. Yes.
I mean, you might get some limited rollover, but actually find yourselves in quite a small group of a much bigger enterprise, better funded enterprise, etc.
My lord, yes. The key point at this point is it's simply uncertain. It's not clear from these documents, and these are the documents that were received by the company. And this is what the company has to look at in complying with its obligations under 6.2. And we say on the face of it, very clearly, these proposals would meet the definition of an opportunity for an exit, not least because simply it's proposing a purchase of 100% of the shares. However, as the judge found, Mr Costa fobbed off Metric, and he did so because he was not prepared to deal with any bidder who was in any way associated with Mr Loy. Given the time, I'm not going to take you to, we've probably seen these passages. Oh, actually, I will just remind you, if I may, of one of the passages. If you go to the core bundle to the judgment, paragraph 70. And I have actually shown this to you before. This is where this is the paragraph relied upon to show that Mr Costa had no intention of dealing with anybody who was involved with Mr Loy. And it actually arose in the context of the Hut Group, which is another potentially interested party. And you see the email at the top of page 195, where Mr Costa says, I have no intention to speak or engage in conversation with anyone who is in touch with him, i.e. Mr Loy. And then the judge makes the finding in paragraph 71, not prepared to negotiate an exit with the buyer who was in any way connected with Mr Loy. And there's similar other findings are relevant here. Paragraph 195. Oh, forgive me, 198. So this is the judge's finding. I think each of the metric offers received prior to the end of 2019 was an opportunity for this purpose. And the question is whether they were given good faith consideration. It seems to me that they were not. On the basis that Mr Costa had by that point already decided he was not prepared to deal with any bidder who was in any way associated with Mr Loy. This cannot in any sense the word be construed as giving good faith consideration to such offers. My learned juniors pointed out I missed an important point in paragraph 71. It's quite a striking point. 71? Yes. Yes. So you see that the middle of the paragraph, Mr Costa therefore began making arrangements for the THD approach to be dealt with, etc. So by him, Mr Uboroy and Mr Minyard of Jeffreys, without involving anyone else in the company. Indeed, he expressly requested that Mr Ringel not be informed of the approach. And Mr Ringel was the CEO. So Mr Costa deliberately excluded the CEO from the process. We say that these findings afford an impregnable basis for the decision that there was a breach of contract due to a failure to give good faith consideration to the opportunities for the exit presented by the metric proposals. Now, faced with those compelling findings, those on the other side are forced to challenge this by means of a construction approach, essentially, just saying that, well, it wouldn't have been an exit. And they'd say that the judge went wrong by introducing a subjective dimension. But that so-called subjective aspect simply reflects the reality of how the clause must operate in practice. Its operation cannot depend upon an objective appraisal several years after the event and with the benefit of disclosure of whether the offer was actually an exit. It has to be based upon what was apparent at the time.
Even with that hindsight, what was the offer?
An offer was never made in the end.
So it's only based on what was discussed in the email 2 months before September.
That was certainly a key piece of evidence that was relied upon on behalf of Mr Costa at the trial to say that Mr Loy was involved in some nefarious dealings with Metric to stitch up a deal that would be to his own benefit, essentially.
But the analysis that this was not an exit is based on what? What is the foundation of the argument that the offer that Metric put forward was not an exit?
Well, my lord, it is that email and then speculation as to how it would have ended up. There's nothing more than that. So there was never an offer in the end. And of course, that's because it wasn't given good faith consideration, we say. So the focus on the construction of the term exit is a red herring. And the judge was perfectly correct to look at whether genuinely this looked like an opportunity that might result in an exit. And on the face of it, that was obviously satisfied because it was an offer for 100% of the shares. And my learned friend emphasised the need to apply the actual words of the agreement. Well, under the terms of the agreement, the Metric proposal was emphatically an exit due to the 100% offer. And insofar as they do speculate as to how the offer would have evolved in terms of rollover, etc., whilst a rollover in respect of some of the shareholdings might reasonably have been perceived to be on the cards, it really is a matter of speculation as to whether the deal ultimately agreed with Metric would have involved a rollover. It's entirely uncertain what proportion of the interest might roll over or which investors would be participating in the rollover. Indeed, these are matters that might have been flushed out if there had been proper negotiations. And on this, the parties were agreed that you would have expected an investment bank acting on behalf of the company to engage in discussions with someone in the position of Metric, and they would have flushed out these kinds of details. Finally, on this, we do say that the judge's analysis of the construction of the term exit is correct anyway. The relevant passages are at 185 to 192 of the judgment. It was common ground that a rollover, at trial at least, it was common ground that a rollover of some degree would have been normal and expected. The question then was whether there would come a point where the scale of the rollover meant that there could not be said to have been an exit or to be an exit. Now, one might perfectly reasonably argue, in my submission, that this wouldn't matter, provided that the terms were at arm's length and the investors were getting consideration. Why would they care that there's some of their number are being reinvested? So that's in my submission, a perfectly reasonable basis to say that the question of rollover is actually a distraction. But if it is necessary to consider the question of substance over form, we say that the judge's approach was perfectly reasonable. And there's no appeal against his finding in the last sentence of paragraph 189 that the risk-reward profile of rolling over the shareholders under the likely deal with Metric would have been very different from before the deal. So if one's looking at substance over form, that's a perfectly legitimate way of accessing that kind of analysis. I also respectfully adopt the observations of Lord Justice Snowden that in a company of this kind, involving critical personnel, it would be surprising if the parties had adopted a definition of exit that excluded the possibility of one or more of the key individuals rolling over. In contrast, the position taken on this appeal on behalf of Mr Costa seems to be that a rollover of any more than a very small proportion of the shares would be inconsistent with an exit. And that's why we say that's unrealistic and uncommercial. Indeed, it's not in keeping with Mr Costa's own closing submissions at the trial, which accept that there would have been some rollover. At least a rollover would have been expected. And the reference for that is paragraph 373.4 of their closing submissions, which is the core supplemental bundle, tab 49, page 287. Furthermore, Mr Costa's own expert, as I said before, agreed that a rollover would be common, and in fact that it would make the company a more attractive target. And Mr Hill's evidence is at paragraph 34 of his report, which is in the supplemental bundle, the second file, tab 43, page 695. So we say ground 2 should also be dismissed. The judge clearly had perfectly good basis for finding that there had been a breach. Moving on to ground 3, prejudice and buyout. As I indicated when dealing with ground 2, we now understand that this ground is based purely on the proposition that the only prejudice that the judge identified and relied upon in making the buyout order was as the result of the breach of the second sentence of clause 6.2, i.e. effectively the failure to consider the Metric offers. That's the only, according to my own friend, that's the only actual prejudice that the judge identified. So on that basis, it said that if they succeed in overturning that finding, the petitioner must fail on prejudice as well. So this ground is now entirely parasitic on ground 2, which I've just dealt with, and we say the judge's findings are absolutely sound. And I've also made the point that it's not clear where this leaves ground 1. If on their case, at least, they're saying that all the prejudice flowed from ground 2. So overturning the finding on ground 1 wouldn't seem to assist them a great deal. But the real point for the purpose of ground 3 is that it's clearly wrong to suggest, from our part, we say it's clearly wrong to suggest that all the prejudice, or the only prejudice that the judge found, was the failure to consider the metric offers. The findings of breach went well beyond the treatment of metric, and therefore very much fell into the realms of the first sentence of clause 6.2, failure to work towards the exit in good faith. They relate to the whole course of conduct, whereby Mr Costa was deliberately failing to progress the exit process. And it was perfectly reasonable for the judge to conclude that Mr Costa, that if Mr Costa had been conducting the process properly, then offers would have been procured. And that indeed was the expert evidence of both parties' experts, both of whom said that if the process that it would have been possible to achieve an exit by the end of the year. That was common ground between the experts, and the references are at paragraph 72 of our respondent skeleton, which is C155.
Starting when?
Around March, I think. So from that period of time, I think our expert went later said October, but there was common ground from that it could have been done from reasonably early in the year. So around the February meeting, so when there's that discussion, there was obviously some focus on the February meeting and the issue around the CEO. So there was a degree of focus on that, and that's how the question arose. And both experts were agreed that if you'd started the clock around that time, so within a short period of time of that meeting, it would still have been very feasible.
But you don't dispute, do you, that at that meeting, in that context, which was anticipating a CEO being appointed relatively soon, there was a resolution that the process would start after the CEO was appointed?
Well, the resolution, query resolution, I mean, it's a bit, we don't accept or fully understand why the minutes record that sentence which talks in terms about not starting until the CEO is brought in. But we would accept there was a recognition that having a CEO would be important for the process, but that should only take a reasonably short period of time to achieve.
There's some evidence somewhere and it may be a finding that actually the process could have taken 10 weeks, or is that different?
I think that's our expert. And metric also, I think. Maybe your lordships had that from something like metric. Because metric's offers only came in the autumn, effectively, and I think they thought it could be achieved. But, my lord, we can see if we can help you on that. One other point, just while I remember, where we're talking about the resolution, your lordship, or so-called resolution, your lordship, referred to at that meeting. It refers to a CEO being identified. It's possibly a small point, but there is a difference between identifying the CEO and then getting them in place.
And they were in place as from the 6th of September.
That's quite right, my lord. Yes.
And I think the reference to 10 weeks is at the beginning of paragraph 38 of the judgment.
Thank you so much.
Which records an agreed estimate that 10 weeks from launch to closing should suffice for the transaction.
Yes. Thank you, my lord. So just returning to ground 3 and the extent of the prejudice flowing from Mr Costa's conduct, and particularly the point that it was the first sentence issue as well as the second sentence issue. It's important to note that the judge did find that there would have been a binding offer by the end of the year. And that's one of the parameters, it's the first of the parameters that in fact, at least one binding offer by the end of the year. And that's the first of the parameters in the schedule. Now, I think yesterday my learned friend seemed to suggest this must have been a typo. And also that if not a typo, it'd make the job of the experts at the quantum trial much easier. Well, certainly we would agree that it's a matter that could be highly influential at a quantum trial of the kind envisaged by the judge, which of course we say is not the way forward. But what is absolutely clear is this is no typo. It was a matter that was specifically discussed at the consequentials hearing. And we have the relevant transcript extract, which is relevant because it shows the judge's thinking about the extent of the wrongdoing of Mr Costa and the consequences it had. So hopefully your lordships will have an extract of the transcript. I think you've got the whole thing. So it's only page 17, you'll be pleased to hear, that you need to start with.
Internal page 17.
Yes, my lord, yes. Internal page 17. And then line 16. We see the discussion here starts between Mr Hill KC and the judge about the formulation of the order. And the structure of the order did change in terms of the paragraph numbers, but here we are talking about the question of how the order should be formulated. Should it be formulated as a straightforward buyout, or should the focus be on figuring out whether the 75 million threshold would be reached? And the key passage begins on page 19 at line 14. So the judge says, let me stop you there. The only thing I would say is that your paragraph 1.1 begins whether there would have been an offer. I thought I was reasonably clear that if Mr Costa had behaved as he should have done, there would have been an offer, and the question at issue is what that offer would have been. And then page 21, the conversation goes on, as your lordships can see. Line 11. I'm reasonably confident that I said, and if I did not say it, this is what I meant, that if Mr Costa had performed his duties as he should have done, the company would have received an offer within the time period. So the remaining issue is what the value of that offer would have been. We start, if you like, with the idea of an indicative offer having been received by a hypothetical bidder. Actually do not mind who they are. But what I think we have to do is go through the due diligence process, if you like.
You must mean indicative of having been made by a hypothetical bidder, I see.
Yes. But there you have a clear decision by the judge. He does think that an offer would have been made, and it's very much premised upon the fact that Mr Costa didn't do what he should have done in terms of working towards the exit.
But a binding offer or a conditional offer? I say here he's talking about a binding offer, because conditional offers are dealt with separately as a second paragraph of the schedule.
He's dealing with 1.1, isn't he?
Yes, unfortunately, the paragraph numbers change by the time we get to the final order. But I can tell you, lordships, the order was agreed ultimately. So there's no controversy that is as intended by the judge and the parties. So it's tab 12 of the core bundle. And I suggest it's clear that the judge is talking not just about the metric offers here, he's talking about an offer by somebody. He says in terms, actually do not mind who they are, a hypothetical bidder. That's lines 16 and 17 on page 21. So overall, we say it's the prejudice flows from the breach of the first sentence and the breach of the second sentence, as far as the judge was concerned. Finally, under ground 3, my learned friend suggested that if he is wrong and the judge's decision on breach of clause 6.2 is upheld, then it's still wrong for the judge to have made a buyout order.
Just on that last point, it may not matter, but it's actually the paragraph just before the first, on page 19, starting at line 5. This is Mr. Hill. Does that, I think, make it clear that he is talking about binding
Yes.
offers?
I'm grateful, my lord, yes. And the judge picks that up.
Yeah, well, maybe. Yep.
Saying there certainly would have been such an offer, effectively. That completes the main submissions on prejudice on ground 3, but my learned friend did add another point at the end of his submissions, which is that even if he's wrong and the breach of clause 6.2 stands, the judge, it was still wrong for there to be a buyout order. And this is on the basis, as I understand it, that if the metric proposal had resulted in a deal, then Saxon Woods would not actually have achieved an exit. I think that's how it's put. So it's based on the idea that the court had to proceed on the basis that the only deal that could have come to fruition was the metric deal, and that under any deal with metric, there would have been a rollover for Saxon Woods. So on that basis, it said that Saxon Woods would not have exited the company even if it had got what it wanted. And so it would not be fair and equitable to grant relief on the grounds that it had been prevented from exiting. I think that's how it goes. And we say it's misconceived on multiple levels. The first point is that in that scenario, Saxon Woods would have exited the company. It would be a shareholder in a different vehicle with different shareholders and different financial arrangements. It is also based on the notion that the deal would have to have been with metric, when there's every reason to believe that other bidders would have emerged if Mr Costa had acted properly. And we've just looked at some of the judge's thinking in that respect. Furthermore, the judge himself records that Mr Loy was not at all wedded to the idea of doing a deal with metric. He was very interested in deals with other parties. And indeed, that's one of the reasons that Mr Loy brought in the Hutt Group. And I'll just give you lordships the references to the judgment, paragraphs 233 and 248 to 249 make it clear that Mr Loy, for one, was not absolutely committed to metric, far from it. And it's also based on the idea that a deal with metric would necessarily have included a rollover, which, as I've already explained, is pure speculation. So this argument, which with respect was presented as a bit of a postscript, should be rejected. My lords, I see the time. I've got one more topic on Mr Costa's appeal, and then I'll be into replying on our appeal.
Yes, thank you. Yeah, so 2 o'clock. Thank you very much.